Welcome to Bankruptcy Bytes, a series presented by the United States Bankruptcy Court for the Eastern District of Missouri. I'm Matt Rodman, Attorney Advisor to the Clerk of Court. Today, we're going to talk a little bit about reaffirmation agreements. Now, let's get into it. What is a reaffirmation agreement? A reaffirmation agreement is an agreement made between a creditor and a debtor that allows the debtor to retain property after the conclusion of their bankruptcy case, provided the debtor follows certain terms and conditions. These agreements most often involve a vehicle or a residence. Reaffirmation agreements are negotiated and agreed upon during the course of the bankruptcy case and before the debtor receives a discharge. Please note, our Bankruptcy Bytes series focuses exclusively on Chapter 7 and Chapter 13 cases. Reaffirmation agreements only apply in Chapter 7 cases and do not apply in Chapter 13 cases where the debtor is subject to a Chapter 13 payment plan. There are some important things to note about reaffirmation agreements. The debtor's choice to enter into a reaffirmation agreement waives discharge of the debt associated with the property that the debtor will now be retaining pursuant to the reaffirmation agreement. This is a debt that would otherwise be discharged in the debtor's bankruptcy case but for this agreement. The debtor remains liable for the debt after the conclusion of the bankruptcy case, and the creditor can exercise their rights under the reaffirmation agreement in the event of non-payment. This might mean repossession of the property if the reaffirmation agreement is not followed. When must a reaffirmation agreement be filed? Pursuant to Federal Rule of Bankruptcy Procedure 4008, a reaffirmation agreement should be filed no later than 60 days after the first date set for the debtor's Section 341 meeting of creditors. How are reaffirmation agreements filed? To reaffirm a debt, the debtor and creditor agree to the terms of the new debt in a written reaffirmation agreement. This written reaffirmation agreement must be filed with the bankruptcy court along with a reaffirmation agreement cover sheet, or official form B-427. Debtors may also reference directors' forms B-2400A, B-2400A/B alt, and B-2400B as appropriate. A complete list of forms can be accessed on the U.S. Court's website at www.uscourts.gov. This will also be linked in the video description below. Just remember, the clerk's office and its staff are strictly forbidden from providing debtors and prospective debtors with legal advice, as we have a statutory obligation to always remain neutral. Everyone's situation is different, and for the best individual assistance, we recommend you speak with an attorney to get expert advice on the right path for you. The decision on whether to reaffirm a debt is not one to be made lightly, and the court strongly urges debtors to consult an attorney to determine whether reaffirming a debt is appropriate for them. If you would like to speak with an attorney regarding your recent or upcoming bankruptcy filing, the Bar Association of Metropolitan St. Louis hosts the St. Louis Bankruptcy Pro Se Assistance Program. This program offers cost-free 30-minute sessions with an attorney where the prospective or current debtor can get the answers to some of their questions. To schedule an appointment, you may call 1-844-758-4059 or schedule online at www.bamsl.org/bankruptcy. Thanks for tuning in to learn a little bit about reaffirmation agreements. This video is part of a series called Bankruptcy Bytes, presented by the United States Bankruptcy Court for the Eastern District of Missouri. I'm Matt Rodman, Attorney Advisor to the Clerk of Court. On behalf of the clerk and all of the clerk's office staff, we hope you find this information helpful, and we wish you all the best moving forward.